have for this morning's session is State versus Calvin. It's 24-1404. We have Melinda Nye for the appellant, Mr. Calvin, Katherine Wenman for the appellee state. Ms. Nye, whenever you're ready.
Good morning. May it please the court, counsel. James Calvin raises 3 issues in this appeal. 2 are controlled by Iowa Supreme Court precedent, and the other issue is an open question that's guided by persuasive authority from this court. I'd like to start with whether Calvin was denied his right to a speedy trial, which is that open question. Specifically, this case raises the question of whether a defendant is required to reassert his 90-day speedy trial rights under Rule 2.33 upon rearrest after an extended absence, in this case 3 years, caused by his failure to appear, and whether a new speedy trial deadline commences upon the date of his initial appearance after rearrest. This court addressed the issue in Treptow and held that a new speedy trial deadline did reset upon rearrest after an extended absence. In Treptow, the defendant failed to appear and was missing for 5 years and was rearrested, and further proceedings were set.
If I understand the state's argument, they distinguished Treptow by saying that there wasn't the same waiver of speedy trial rights, and that here there was required that your client would have been required to rescind the waiver.
That's how the district court distinguished Treptow, and that is one way to distinguish Treptow. But also, the holding in Treptow was not so narrow. It didn't rely specifically on that he hadn't waived. It was about the extended length of, sort of the idea that this extended length, things needed to restart because it's been so long, nobody knows where we're at and what's going on. So it's only fair for everybody if we restart it after 5 years, and it compared it to instances where cases are remanded after an appeal or a mistrial is declared. But also in Treptow.
I just want to quickly interrupt to ask, State v. Hamilton is pretty clear. It's a case from, I think, 1981 that indicates definitively that if a waiver is made and you want to, you have to file a formal rescission, right, to take that away. Why would that not apply here? And I think it gets to the definition, right? Like, what is the definition of reset?
Yeah, definitely, normally that's how speedy trial gets, when a defendant wants speedy trial to start again and wants to reassert, you rescind it. But I think also the way that Treptow analyzed it, and if you look at note 4 in the Treptow opinion, they distinguish that from, normally a defendant's absence is just counted towards, we look at good cause to exceed speedy, and that's, when the client is missing or when the defendant is missing, that's just considered, it's charged against the defendant. It's his own fault that things exceeded. And they said that note 4 says, you don't look at that like that. This extended absence is somehow qualitatively different and is more like when a case has been remanded after an appeal. And so somehow that extended absence, whether it's, just based on the premise that, like I said, the reason we have speedy trial deadlines in the first place is like time makes things, the longer things go, it's harder to have a fair trial, and memories wane, and so setting this new deadline is the best policy. So
even if it wasn't like a total fresh start reset, were there things that the defense argued below when, I think there's a pro se motion where your client talks about like his 90-day trial rights being violated, and it seemed like the state viewed that maybe as rescinding the waiver because they argued good cause. So what do we make of that?
So there was a lot going on in, and that's part of when we get to whether speedy trials, like if you agree that 90 restarted, sort of what happens there. So we have a lot of pro se filings, but he is, at that point, he's represented by counsel, so those motions are not considered on their merits, they're not considered. And so when counsel finally agreed to file something, what was raised was this very narrow, I would love to say he rescinded his rights, and certainly if we're not successful in this appeal, there might be some PCR claims made for not rescinding the rights. But clearly, Calvin thought he had his, if you look at those pro se, he thought he had speedy trial rights running, and that sort of shows how important that extended lapse, that extended absence, how that affects memories and people understanding of where they're at in the case. There's also no, sort of on that line, there's no indication that he's ever advised or reminded that he's under waiver either. So, for him to say, oh, I better rescind that, there's no advisement that we can tell from the record. So yeah, that's a pretty sort of narrow issue. There's really this Treptow is the basis for the argument that it resets. So if there's no other questions, I would turn to the motion for new trial, which is now, as far as I know, there's been a split on this court about whether counsel would need to, ask the district court to correct, if it applied the incorrect standard, to ask the court to bring it to the court's attention and ask the court to apply the correct standard. And in my notice of additional authorities, we can see that Jackson, recent case, has now been taken on further review. Could be 8 months, but hopefully that issue will now be resolved. But I would say, so at this point, I think binding Supreme Court precedent is if the issue is raised by counsel and
The motion for new trial was kind of a mishmash, wasn't it, of substantial evidence and weighted evidence?
I agree. Both were raised, but it is clear, I think, particularly paragraph 10 is an affirmative assertion. The defendant is entitled to a new trial based on the fact that the evidence is insufficient to sustain the verdict and that the jury's verdict was contrary to the law and evidence, and cites the appropriate rule, although an older version of the rule. So I think that's an affirmative argument. It's bolded. It's a heading there. And then, as I've sort of laid out, there's support explaining the difference between the two analyses, between sufficiency and weight. And then when we get into the sentencing hearing, the court says, okay, you filed everything. Do you want to say anything in addition to what's in your motion? And he said, no, I'm going to stand on my motion, but here's some more argument. And then really focuses on sufficiency in the sentencing hearing.
Why doesn't it make sense to call the error in the court standard to the court's attention at a time when it can be corrected?
I don't think there'd be anything wrong with doing that. But it's just never been required for error preservation. We, in all sorts of contexts, evidentiary challenges and other sorts of, without even going to sentencing, being sort of its own beast. But in other sorts, evidentiary motions, and when the court overrules and applies the wrong standard or doesn't do the full analysis under a 403B or, hearsay, they don't have to call, they've got the ruling, that's what it takes. You bring it to the court's attention and you get a ruling. And if the court messes up the analysis, that's an abuse of discretion. But there's not. We don't.
I'm only going to ask this just because you brought up the hearsay objection. No, that's okay. And I'm with you a little bit, okay? I hear you. But let's say a hearsay objection's made, right? And then the district court says, overruled, I think it's relevant. Does counsel not have some obligation to be like, Judge, I brought a hearsay objection, not a relevance objection? Because that's really what it gets to the heart, for me at least, is like, we didn't even flag to the court that like, hey, you're not doing what I asked you to do in terms of in the right category. That's what I struggle with.
Yeah, what I'm talking about, and what I think happens in my case, or in this case particular, is the court says weight of the evidence. says I'm ruling on your motion for new trial, but then just adds in this, and I'm going to consider the evidence in the light most favorable to the verdict, which is, so I think there definitely is a ruling on the motion for new trial in this case. There might be one where there just absolutely is no ruling, where they only address sufficiency. I think there's,
Written ruling, it says, I'm deciding this under Ellis, right? So,
and says weight of the evidence, but we know from looking at what the court thinks the weight of the evidence means, it still means I'm considering the evidence in the light most favorable to the verdict. And then it throws in with the Ellis, you know, he got a fair trial, not a perfect trial. I don't know what that goes to exactly. You know, that's a completely different test. But there's definitely, sorry if I could just finish, definitely Supreme Court authority where things have been very muddled, and even when defense counsel is offering the wrong standard or admitting, I don't know what the standard is either, we remand because it's such, the motion for new trial is such a unique sort of ruling, and I guess I'll finish that on rebuttal.
Thank you, Your Honor. May it please the court, counsel. I want to start with the 90-day speedy issue. And I want to take us to State v. Hamilton, which Judge Sandy, you brought up. And I think State v. Hamilton is a really interesting case to look at here, not only because State v. Treptow relies on it heavily, but because it lies out for us what happens when we have sort of a pause play versus the restart of a proceeding. So State v. Hamilton, in that case, Hamilton sought interlocutory appeal, went through the appeal proceeding, came back on procedendo, and then rescinded his 90-day waiver. And what Hamilton tells us is both that rescinding your waiver is what restarts a 90-day proceeding, but also that procedendo is typically another reset point unless a waiver is on file. So what that tells us is that if we have an extended period of time, in Hamilton, that extended us past the 1-year requirement, also found in our speedy trial set of case law. If we have a extended period of time, that coming back to the district court proceedings, even if we have sort of these reset points that have been carved out in our case law, if there's a waiver on file, that waiver survives until it is rescinded, if we're in the same proceeding.
is your argument that Treptow was wrongly decided or that it misanalyzed Hamilton?
I don't believe so, because there wasn't a waiver on file. And so Hamilton says, absent a waiver.
Then it seems a little like one-sided. So the restart's only for the state. Like the defendant doesn't get a restart.
Well,
The waiver stays in place for the defendant, but the time restarts for the state.
I don't think that that's necessarily true, because the defendant always has the power to redemand his speedy trial rights. So we have these reset points in place because there does, if a defendant has not waived their speedy trial, we have these sort of carved out reset points. The defendant always has the power to say, I would like to restart here. So that power is always balanced because the defendant always has that restart button in their pocket.
Both sides were maybe reading Treptow as a full restart because, again, the state asked for a good cause hearing.
That good cause hearing, my reading of it at least, is for extending past the 1-year period, which would have run February 21st of 2022, because the February 21st of 2021 in this COVID era that we were in was sort of the hard reset. For when the, at that point, 120-day speedy trial would have gone. So the good cause determination there was for going past the 1 year because of Mr. Calvin's absence. I think everybody was a little curious about what exactly was going to happen, but I don't believe that there was this sort of agreement that the 90-day clock had reset by the state. And there, sorry, go ahead.
If we're looking at kind of making a workable, bright line rule for everybody so that there is no confusion when he's rearrested and comes back as to what's going on, wouldn't it be better to say that speedy trial restarts at rearrest? I mean, you have an initial appearance, maybe there was a waiver of counsel earlier, but you still get appointed counsel again.
I do think, though, that, he had a motion to suppress before he was rearrested. That doesn't get reset. All of those proceedings that occur before aren't wiped away, and we're still within the same proceeding. So I don't believe, especially when we think about things like an interlocutory appeal, which I think is our closest parallel, this seems closer to sort of a pause play, where we're coming back to the same proceeding and not where we're restarting a proceeding. He's not being reindicted. He's not being rearraigned. This isn't like withdrawing a guilty plea or coming back for a mistrial or being remanded for a new trial, which are all sort of judicial, not really judicial fictions, but all things that put us into a new proceeding and send us forward as if we've gone back to indictment and arraignment. And I'll point out that none of this is contemplated by the rule, right? The rule says 90 days from indictment, a year from original arraignment. These sort of reset points are case law created because we want to make sure that the state has a fair opportunity to try somebody. And again, as I pointed out, Judge Tabor, because the defendant always has that 90-day reset from a rescission of their speedy trial right, or of their speedy trial waiver. I do want to talk some about these pro se filings. 814-6A tells us that we do not consider those pro se filings, even if we wanted to, which again I think is a bad option under the statute. His earliest one, I believe, was May 1st. So by June 18th, we were well within the 90 days, if that's the earliest we want to consider sort of a redemand of his speedy trial rights. But again, we shouldn't be considering that filing at all. So I think that sort of is our best way to consider the speedy trial right, is sort of as Hamilton considers interlocutory appeals. Moving to the weight standard, I think it is an interesting consideration when you look at particularly paragraph 16 of Mr. Calvin's motion for a new trial, which says, under the sufficiency of the evidence standard, viewed in the light most favorable to the state, there is insufficient evidence to support the guilty verdict for the charged offenses. The evidence supports a not guilty verdict. In this same motion, Mr. Calvin says that the district court erred in not granting his motions for a directed verdict, which are sufficiency motions. He argues that there is not substantial evidence, which is the sufficiency standard. He argues using sufficiency cases, Bachmeier and White.
Resistance gets it right? They just argue Ellis, weight of the evidence, all the way through the resistance.
The state recognizing that it's a motion for a new trial, and that is typically a vehicle for a weight challenge, is not dispositive of the issue that is raised, which is a sufficiency issue.
The point is the defendant sort of misled the court on what he was asking for. I mean, the state got him back on track, right? The county attorney was clear about what the standards were. So the court had that before it when it was ruling.
I do think that in some ways, Your Honor, elevates form over substance, right? If the court would have answered a weight question when what the defendant was asking was a sufficiency question, we would have the same problem, but for us, right? If they're asking for sufficiency standards, the only time that they mention weight is in laying out the difference between the two standards. And then everything else that Mr. Calvin says is, please answer my sufficiency question. And the district court then answers a sufficiency question.
Under the rules, it couldn't answer the sufficiency question, right? So the court had the correct standard in the state's resistance. So I don't think it could say that it was misled, right? Because, I mean, we've had decades of this. Like, it still surprises me that people can't get it right.
Absolutely. I think it's similar to the way that if on appeal, somebody asks for a discretionary review or a writ of cert or a notice of appeal, they might use the wrong term or bring it at the wrong time, but we answer the question that's in front of us. In the same way that, when we are still seeing more sufficiency challenges raised in a pre-Crawford world, if they might have done it in a motion for a new trial rather than judgment notwithstanding the verdict, we wouldn't say that the heading of the motion was the dispositive moment. The timing might be important, but we look at the substance of the motion. And the substance here is sufficiency. He cites sufficiency cases, in cases where sufficiency is the only issue. He cites the sufficiency standards as the controlling standards. And so to say that the district court erred in answering the specific question put in front of it when then the defendant never came back and said, that wasn't quite what I was asking for, actually. I think if we look at the special concurrence in Reth Switch, obviously the lead opinion says that this would need to be preserved by flagging that there would be, that the wrong standard was used. But if we look at the special concurrence in that opinion, there it says that we don't typically require error preservation when the rule is cited, the correct standard is argued, the correct case law is cited in support of that argument, and the correct standard is urged at the hearing. We don't have those preconditions here. Apart from the one paragraph where it lays out the Ellis standard, there is no weight evidence or no weight argument made in this. And so even under sort of this Reth Switch special concurrence, I don't think that those preconditions are met. Now, I recognize that we have a Supreme Court case probably coming down the pipeline that's going to tell us whether or not this motion for a new trial issue needs to be preserved. I do think, though, because a weight challenge was never made, that State v. Jackson decision might not even be required to make this determination here because a weight challenge was never levied. And so even just our standard Meyer v. Sennecut error preservation rules would say that this issue was not raised, it was subsequently not ruled upon, and so our standard error preservation rules have not been met.
Issue, you asked for a limited remand, but you don't really mean limited remand, right? You don't want us to retain jurisdiction.
Order new pro tunc would probably be sufficient. For these reasons, the state asks that this court uphold Mr. Calvin's convictions and remand for entry of an order new pro tunc to address his fine. Thank you very much.
Thank you. Just briefly, I do agree. I do think it's interesting that you were asking about Treptow being, maybe it was wrongly decided. I do think it's inconsistent that if this court holds that his absence doesn't reset 90 days, I think it calls Treptow the rationale into question, because it's an unfair, it's good if it helps the state get someone to trial, we got to give them some more time, but when it's the defendant, we're not going to give them a hard stop at a new 90 days. We're going to let this go on. But mostly, on the motion for new trial, I wholeheartedly disagree that this wasn't raised in the motion.
I want to address that last point just very briefly. The reason, though, that we're even talking about needing a resetting, right, is because somebody absconded, right? I mean, and so I understand that, like, if we're looking at the analytical framework of things, that doesn't play in as much. But I do think it's a little bit specious to say, well, the state gets the benefit of the state didn't choose to delay the trial by 3 years because somebody disappeared, right? And so it's the cards that was dealt.
But also, I think the proper analysis, if it doesn't reset in this kind of a case, if the reset isn't about just the length of the absence for whatever reason, even defendant's own fault, Treptow should have just counted his absence against him as good cause in going past speedy trial. Like that would be the intellectually consistent, legally consistent way to approach it. So. And in the motion for new trial, I think, when you look at this motion, we have a heading, paragraph 3 is court erred in declining to grant the motion for directed verdict, and then there's a lot of talk about sufficiency of the evidence in the next 7 paragraphs. And then paragraph 10 is a new bold heading, defendants entitled based on that the verdict was contrary to the law and the evidence, and cites the rule. And then the next 2 paragraphs cites Reeves and what's the other, Nitcher, and other cases that are all about weight of the evidence. And so I just don't know how that's not. I mean, I might have organized this differently if I had been writing it, and because then at the end it sort of flips back and it tries to wrap up. I think the organization maybe could have been a little cleaner, because it does sort of jump back to the sufficiency then at the very end. But I think it's pretty clear that this was definitely raised, that both pieces were raised.
Any purpose to raise the sufficiency, though, right? The organization would have been better just to exclude that part.
Yeah, but we see it pretty frequently that both get thrown in there, and probably because we harped on them so long, but we do this appellate training, we try it, but you know, that before Crawford, it was so important to get it, and you know, it was, if they didn't make a sufficient motion earlier, they want to back it up with the motion for new trial and throw in their sufficiency just to try to, you know, preserve it for an appeal, and that's, you know, I think word is still getting out that that's not necessary anymore. So, and I do think it is, you know, I recognize, you know, inefficiencies and remanding just for this one finding, but ultimately it's the court's responsibility to know the correct standard to apply. Like you said, it's been around for 25 years now. And so ideally, defense would make a full-throated motion for new trial, arguing, you know, but we have existing case law that says just saying weight of the evidence or just citing the rule is enough to raise it. And then I think, as this court's also noted, that if the court would make findings and actually not just deny it, you know, pro forma, but to actually make findings on the record about why the weight of the evidence supports the verdict, that would be ideal.
Recommendation be for us to wait until there's a decision issued in Jackson?
You have to move forward. I mean, I thought of that. I thought about a motion to stay when I saw Jackson got granted, but we have these other issues. And depending on, you know, I can't speak for Ms. Wenman, but depending on how the court decides the motion for new trial issue, I suspect either one of us is going to file for further review to sort of get it maybe caught up into the Jackson decision. But given that there's the other two issues should be resolved, like I think the case should keep moving forward and the court should follow existing authority in deciding this issue. All right, thank you.
Appreciate your really helpful arguments today and the good briefing in this case. We will consider State versus Calvin submitted and we'll issue a written decision as soon as we can. Thank you.